Hi everyone, in this week's dispatch video we're discussing maternity pay, and specifically in this case the discretion to operate an enhanced maternity pay scheme. These have become more prominent in recent years as employers try to keep up with the fringe benefits that many competitors are offering, and one of the areas that is looked at is more generous family-friendly schemes. Now, it's obviously not possible to contract out of the statutory maternity pay provisions, which provide a minimum entitlement for mothers going on leave, but it is possible to provide a contractual right for an enhancement to that SMP entitlement. The starting point for any such entitlement is that it's deemed that any enhancement will include the statutory maternity pay element for the week. There are two main ways that maternity pay tends to be enhanced. That's either full or part payment of salary for part or all of the maternity leave period. That's the most common way that we see employers operating this scheme. The alternative is to offer some sort of bonus arrangement for the employee being encouraged to return back to work. So that would generally be payable at the end of the maternity leave period or after a period of time that the employee has remained with the business post-maternity leave. So what do we do about implementing a scheme such as this? Well, obviously it has to be written down, and the drafting is very important in these cases. There are a number of limits on the contractual schemes which we tend to recommend including. The first one being that a particular qualifying period of employment needs to be served before the enhancement applies. Now, typically that is 1 year of employment prior to the 15th week before childbirth, which ties in with the statutory maternity pay qualification provisions in terms of that qualification week. We will often provide that employees who return from a period of paid maternity leave will not qualify again until they've completed a certain period of service, which might, for example, be 2 years. And thirdly, if we want to put a provision in place that requires the employee to come back for a certain period of time, we are absolutely entitled to do that. And typically what I see being required is that the employee comes back for at least 6 months, or if they don't do so, they have to repay all or part of that enhanced maternity pay that's being provided. And now, if we do put that clawback provision in place, we do need a contractual agreement for those deductions to apply, and that crucially has to be agreed prior to the maternity leave period and prior to creating that enhancement. We obviously can't claw back the statutory maternity pay element, but we do need some prior agreement, typically by letter, setting out those enhanced arrangements and that the employee signs to confirm that they will be returning to work, and if they don't, the employer has the right to require the employee to repay those sums. Linked to that, the other element we have to consider here is what is the reason for the employee not returning ultimately. And this works similarly to a training costs clawback clause. The way we tend to advise is that if the employee voluntarily decides not to return after maternity leave, or perhaps is dismissed for fault-based reasons during the repayment period, those are the only occasions you would generally require repayment. If, for example, the employee takes enhanced maternity pay and then is made redundant for reasons beyond her control, tribunals and courts may be less willing to allow that type of repayment proposal, and so I would always link it to the employee's voluntary decision or a fault-based dismissal. So I hope that rundown of enhanced maternity schemes is useful to you. If you do need any further advice on this or anything relating to employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.